Why do smart jurors sometimes make bad decisions? Because trials do not just test facts. They test attention, memory, emotion, and the story a lawyer builds in the room. According to Pace University's Hobb Law Advocacy blog, the real battle is often not only what evidence says, but how jurors process it. That makes this a trial skill story. For lawyers, the lesson is persuasion through clarity, structure, witness control, and disciplined presentation. Start with this idea. Jurors are human first. They bring assumptions, shortcuts, and emotional reactions into the box before opening statements even begin. The article points to 3 pressure points: pretrial bias, cognitive bias, and influence from outside legal actors, especially expert witnesses. One major risk is early commitment. A juror starts leaning one way, then quietly bends later evidence to fit that first impression. That pattern has a name: predecisional distortion. Research by Catherine Carlson and J. Edward Russo showed mock jurors often interpreted new evidence to support a verdict they already favored. For trial lawyers, that changes the job. The goal is not just to present evidence. It is to shape first impressions carefully and avoid feeding premature conclusions. Voir dire matters here. So do questions about prior publicity, online exposure, and what jurors may already think they know about the case. The coaching point is simple. Do not let the first clear story belong to the other side. Now, move to cognitive load. Jurors are asked to absorb law, facts, testimony, objections, timelines, and expert opinions under pressure. When that load gets heavy, people use shortcuts. The article explains heuristics as fast mental moves that reduce effort but can also distort judgment. That is why legalese is dangerous. If the language sounds dense or abstract, jurors may stop processing deeply and start guessing. The National Center for State Courts has long supported plain English jury instructions because clearer language improves juror understanding and recall. Think of the juror's mind like an overloaded briefcase. If lawyers keep stuffing it, the most important documents get lost. For courtroom practice, that means shorter sentences, cleaner themes, fewer labels, more concrete nouns and verbs, one point at a time. The article also highlights the rule of 3. Grouping ideas in threes can make arguments easier to follow and remember. That is a useful trial drill. Take any opening theme and reduce it to 3 plain claims the jury can carry into deliberations. Next comes tone. Many lawyers think sounding detached makes them look more credible. The article argues that is often backwards. If a lawyer sounds cold, jurors may hear competence but feel no connection, and connection affects trust. This does not mean perform. It means speak like a real person who believes the facts matter. Concrete language helps. Saying what happened in visible terms gives jurors something they can picture, not just something they are told to accept. That matters in blame judgments too. Research discussed in the article suggests abstract and dispositional wording can increase harsh attributions, while concrete and situational wording can soften them. For advocates, this becomes a skill question. What exact verbs are being used for the client, the witness, and the opposing conduct? A strong exercise is to rewrite one argument 2 ways. First, in abstract labels, then in concrete action words. The difference is usually immediate. Expert testimony creates another layer of persuasion. Jurors do not evaluate only the science, they evaluate the person delivering it. The article draws from published research in medicine, science, and the law, showing juror reactions can shift based on evidence complexity, witness style, confidence, presentation format, and perceived credibility. That is especially important with forensic evidence. National Institute of Justice reviews note that juror comprehension can change depending on how experts explain statistics, probabilities, and limits. DNA is a good example. Jurors may treat it like pure certainty, even when the real question is how strongly the result supports one explanation over another. So the courtroom skill is translation. A lawyer must help jurors understand what the expert knows, what the expert does not know, and what the method can actually prove. That applies to direct and cross. On direct, simplify without overstating. On cross, separate scientific limits from courtroom confidence. Witness preparation matters just as much. The article warns that restless, repetitive movements can read as stress or deception to jurors. A witness who fidgets, grabs water constantly, or shifts in the chair may be telling the truth and still look unreliable. That is why practice should include delivery, not just answers. Pace, posture, pauses, eye contact, and stress habits all shape credibility. So, what is the big takeaway for trial lawyers? Juror persuasion is not magic. It is disciplined communication under human conditions. The article from PACE, backed by research from journals like Journal of Experimental Psychology, Applied, and Medicine, Science and the Law, points to the same lesson. Jurors remember clear stories. They trust speakers who sound human. They struggle with clutter. And they react to tone, framing, and witness behavior. That gives lawyers a practical training plan. Sharpen voir dire, strip out jargon, build themes in threes, make expert testimony understandable. Rehearse witness presence, not only substance. Next time you prep an opening, choose one issue and explain it in plain English, with concrete language, in under 30 seconds. Practice that skill with AI-powered courtroom drills at trialtutor.com. And if this breakdown helped, like, subscribe, and share it with another trial lawyer.